Hey again, everyone. It's Rob Ryder on Tuesday, October 19th, 2021. And I hope I sound okay. I had to use my old headset because something happened to my new one, or newer one. So let's see how this goes. But today, exception and notice. And this is based on Federal Rule of Civil Procedure 5.1, which talks about the constitutional challenge to a statute. Well, a challenge is an exception. And an exception is an allegation of a party in writing that some pleading or proceeding in a cause is insufficient. Right? These are legal terms, have legal definitions, and well, there you go. Now, I had tried prior, right? Just a little background in case this is the first video you're watching on this. Where was it? 3 months ago, I did a video called Notice of Constitutional Question and Subpoena, talking about some stuff that I had read in the Florida Rules of Civil Procedure and giving an idea of what I thought we should try or somebody should try, because I don't have a court case, so I can't try these things. But at the end of the day, we're just talking about throwing paper in a court and seeing what the court does with it, right? I mean, you can't go to jail for filing paper in a court, so what the hell? File something in if you have a court case. Well, a gentleman did, and a little bit of time ago, and that led to my latest video, which was Constitutional Question Ends Foreclosure in a New York Minute. And I did it, we were looking at all the documents in the court case there and what the judge had said, or magistrate, whatever you want to call them. Right, they're really not a judge of a state court because they haven't taken a proper oath of office, which is really what the basis of all this shit's about. Anyways, before I forget, so somebody asked me, well, how did I hear about this case? Well, brother, the guy who had the court case called me. Right, he had watched the videos. That's why he had done it. Well, having read it again and again and again since then, I've come to a different understanding. And, while I thank the judge for what she did in this case, because she did dismiss the case, and we'll look at what she had to say about it. But it wasn't, she didn't say she did it because of the constitutional question. And as I look at it now, well, we didn't ask the right question and we didn't phrase it right, and all sorts of things that I had done wrong, because of my first interpretation of what the documents were saying. And when you don't have anything to compare it to, all you can do is go ahead and try. That's what we did, and now I'm adjusting my fire. I want to try it again a little bit differently. And that's what this is about. So I am Staff Sergeant Robert Allen Berlusky, United States Army veteran, U.S. Army veteran, a.k.a. Rob Ryder. And my email address is courtofrecord@aol.com. If you leave a message on a video, I'm not going to be able to respond. Anytime I've ever tried to respond to one of those, my answer and the question both disappear. Right? So is that called shadow ban? I don't know. But all I could tell you is, I can't answer that. You want to ask me a question that you want answered, you have to send me an email. Hopefully I'll be able to answer. I might tell you that, I can't answer your question because people ask a 2-sentence question that would take me, days and days and days trying to answer. I just can't do it. Anyways, if you were to Google, Federal Rules of Civil Procedure, Rule 5.1, this is what it would say. It would say that it's a constitutional challenge to a statute. And it would go on to say notice by a party. A party that files a pleading, written motion, or other paper drawing into question the constitutionality of a federal or state statute must promptly file a notice of constitutional question stating the question and identifying the paper that raises it. So we should just stop there. Obviously, the notice and the identify the paper are two different documents, right? So first you have to file a challenge, which is an exception. Because a challenge, with using the term challenge, is a particular kind of exception, where an exception, using challenge just as a common noun now, right, is a way to challenge what's happening in the court case. So what I'm saying is it's really not a challenge you're putting in. You're putting in an exception to challenge the court case. We'll see in just a second. Right? So, but if you put something in, so that would be this other paper. Well, what's the other paper? Well, that's your exception. Okay? Drawing into question the constitutionality of a federal or state statute. Check. If you do that, then you have to file a notice of constitutional question, stating the question and identifying the paper that raises it. If a federal statute is questioned and the parties do not include the United States, one of its agencies, or its officers or employees in an official capacity, or a state statute is questioned and the parties do not include a state, one of its agencies, or one of its officers or employees in an official capacity. And this is where we're going to see here in a second that, again, point out there is a difference between the United States of America, which is a foreign jurisdiction to the United States, right? It's not the United States. So when they have the United States of America as the plaintiff, that's not the government of the United States. It's a foreign jurisdiction. We'll see how that plays out in a second. Serve the notice and paper on the Attorney General of the United States. If it's a federal question, the State Attorney General. If it's a state statute, either by certified mail, registered mail, or by sending it to an electronic address designated by the Attorney General for this purpose. And we're trying to find that out right now. Does the U.S. Attorney General have an email address that you could just send this to? And then that would take care of the notice. I didn't have an answer yet, and I didn't want to wait for an answer to do the video because I can just, share it at a later time. But just so you know, there could be as easy as an electronic address. And so if I get it here soon enough, I'll just put it in the comments of this video, and then I'll talk about it in another video later on. But, if you're looking to do this, you either have to send it by mail or figure out if there's an electronic address. Right? Certification by the court. The court must, under 28 U.S.C. 2403, certify to the appropriate Attorney General that the statute has been questioned. Okay? Intervention, final decision on the merits, unless the court sets a later time. Attorney General may intervene within 60 days after the notice is filed, or after the court certifies the challenge, whichever is earlier. Before the time to intervene expires, the court may reject the constitutional challenge. They may not enter a final judgment holding the statute unconstitutional. No forfeiture. A party's failure to file a serve a notice of court's failure to certify does not forfeit constitutional claim or defense that is otherwise timely asserted. Okay, so everything I'm going to do now is going to be based on the first law passed after the ratification of the Constitution of the United States, which is commonly known as 1 Stat 23, which is an act to regulate the time and manner of administering certain oaths, which in that act specifically says, this is the oath that satisfies the 6th article of the Constitution of the United States, and then it gives the oath. Right? I state your name, you solemnly swear to support the Constitution of the United States. Period. So, what I'm doing today is based on a foreclosure case, but you could use this in any court case as far as I'm concerned. You're going to be questioning if that's what that law says, that they're supposed to take this oath and they haven't taken it. Well, then, is the statute constitutional? And if yes, well, then what they're doing is unconstitutional because they don't have this particular oath. And somebody asked me, well, how do you find the judge's oath? Well, you write to the state, Secretary of State, and you write to the county clerk. I mean, that's who has them in Michigan, right? Either the state officer, the Secretary of State's supposed to have a copy, and if it's a county officer, then the county clerk's supposed to have have a copy of it. Other than that, I couldn't tell you. You just, I'm going to go with the fact they don't have one and then make them prove it, which is part of what they have to have. See, they have to be able to prove it by having a record or a certificate that they had done these things. We'll get to that in just a second. So let me load up a few other papers here. All right, just a few minutes on some definitions. So this 28 U.S.C. 2403 is what it talked about in Rule 5.1, right? That in any action, suit, or proceeding in a court of the United States, to which the United States or an office or agency, not a party, Constitution of the Act, Congress, affecting public interest is drawn into question, the court shall certify such fact to the Attorney General. All right, so that's what they're supposed to do. Challenge, right? If you go look up the definition of challenge in a legal dictionary, well, this is an example of what you find. A challenge is an exception made to jurors who are to pass on trial or to a judge or to a sheriff. All right, so it will be proper here to consider the several kinds of challenges and by whom they're made, the time and manner of making them. Excuse me. Okay, so then you have preemptory challenges, are those which are made without assigning any reason, in which the court must allow. Challenges for cause are to array or to the polls when it has to do with jurors and so forth. Well, we're really not at that point yet. See, I think that the challenges have to do with challenging your jurors in a court case. But exception, right? Because it said that the challenge is an exception. So what's an exception? In chancery practice, it is an allegation of a party in writing that some pleading or proceeding is in a cause is insufficient. Okay, well, that's what I say we have, right? We have an insufficient pleading or proceeding because the officers in the court don't have a proper oath of office. Right? Exceptions are dilatory or preemptory. Dilatory are not tend to defeat the action, but only retard its progress. And peremptory exceptions founded on law are those which, without going into the merits of the cause, show that the plaintiff cannot maintain his action either because it is prescribed or because the cause of action has been destroyed or extinguished. These may be pleaded at any time previous to a definitive judgment. Right? The exception, by exception is also meant the objection to which is made at the decision of a judge in the course of a trial. See Bill of Exception. And again, that's at a trial, right? And in the United States, if it's $20 or more, you're supposed to be in a trial by jury. So if you're not sitting in a trial by jury, well, you're not in a trial yet. So I say this is preemptive, right? This is what we're trying to do here. Peremptory exceptions founded on law are those which, without going into the merits, forget whether I owe you the money or not. That isn't the question, right? The question is, did they bring it to the proper jurisdiction? And for it to be the proper jurisdiction, the judge has to have taken oath to satisfy 1 Stat 23. Simple, right? Don't make it any harder than that. All right, so that was my idea. So now what? How do you put it into action? Well, first of all, you got to write it down. Now, I don't need to send this to you people. You people, forgive me for saying that. That really that most of this you could just copy and paste what you knew where to look. There's, very few sentences you would actually have to type out yourself. But at the end of the day, you need to know the name of the court. I'm saying don't use the name of the court that they use because they're not using the proper name of the court. I'll show you an example in just a minute. Right? But if you want to know what the proper name of the court is, I'd say, well, call the clerk of the court and say, hey, what's the proper name of the court? Right? If I want to file a document properly, I need to have the proper name of the court. Can you please tell me the proper name of the court? And whatever the clerk tells you, put it down. Right? Then you got to have a plaintiff and a defendant. Now, this would come off of whatever court case it is that you're talking about, where the defendant probably isn't you in your full legal name, although it could be, right? But whatever they have for the defendant, put that down. Whatever they have for the plaintiff, put that down. Whatever they did, and the case number, or what do they call it? They got a different name for it in New York. They don't call it a case number. We'll find out in a minute. But right, then you got to have a title. Exception. That's your title, right? What are you doing? You're putting in an exception. It's not a motion. It's not an application. It's not a pleading. It's not an answer. No, it's an exception. Challenging this proceeding and the constitutional qualifications of officers of the court. Right? We're going to challenge the proceeding and the constitutional qualifications of the officers of the court. This proceeding is unconstitutional and a malicious prosecution unless the officers of the court involved have executed the oath in an act to regulate the time and manner of administering certain oaths. Maybe that one Stat 23 I keep talking about. And provide parties of interest a record or certificate to prove that they are qualified in accordance with said act. Right? Because the act says they got to have this piece of paper. All right, now the People's Law Dictionary, which was by Gerald N. Hill and Kathleen T. Hill, defines an officer of the court as any person who has an obligation to promote justice and effective operation of the judicial system, including judges, the attorneys who appear in courts, bailiffs, clerks, and other personnel. And Black's Law Dictionary, 2nd edition, defines a judicial officer as a justice of the peace, magistrate, or judge, or any other officer of the court. All right, so anybody who's an officer of the court is a judicial officer. So then, and whereas the 3rd section of the 6th article of the Constitution of the United States requires the senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office of public trust under the United States, and whereas an act to regulate the time and manner of administering certain oaths, maybe that one Stat 23 again, right? Exhibit, so, we'll get to that in a second, is the first act of Congress signed into law after the ratification of the Constitution of the United States and was incorporated into the United States statutes at large as one Stat 23, in which it is enacted. The oath or affirmation required by the 6th article of the Constitution of the United States shall be administered in the form following, to wit, I, A, B, would be state your name, right, full legal name, do solemnly swear or affirm that I will support the Constitution of the United States. Whereas 1 U.S.C. 112, Statutes at Large, Contents, Admissibility, and Evidence, requires that the United States statutes at large shall be legal evidence of laws in all the courts of the United States and several states and the territories of the United States. Then a place to put your name, print your name in there. A party of interest, right? Put your full legal name, not the name of the defendant, your full legal name. A party of interest damaged by this simulated legal process under color of law requests damages for occurrence of an intentional tort and prosecution of public officer impostors. All right, then you sign it down here, print your name, So, when you did this for yourself, it wouldn't take up nearly the room that I have this laid out here like this, but that's what you have to do when you're trying to leave lines for people, right? Because you're going to have room to put the name of the court, put the plaintiff and defendant, put the case number, and, for me, I like to get it all on one piece of paper. I don't think it should be on two. You should be able to scrunch this down and get it all on one piece of paper. Have it really legible, easy to read. 1, 2, 3, pointing out all the facts. Now, the exhibit, right, is along with this document, then you're going to file an exhibit. And the exhibit's going to be a copy of 1 Stat 23. So now you're going to ask me, well, where do I find that? Let's go look. Hang on a second. Okay, so, my preferred ones is, let's just start. All right, let's look at this one, Wikisource. All right, this has got all the text in it, but it's, really not that proper of a form. And when you try to copy and paste it, it throws all this stuff in there, and it makes it really difficult. So it's not necessarily the best choice, but it does have all the words. So, you could use it. All right, 1stat23, U.S. law link. Well, let's look at that. If we click there and we go to Legis Works, see what it has to say. Hey, yeah, you could use this one. I mean, this would be perfectly fine. This is, the one I'm talking about. This right here. Print this out. Right? This is going to be your Exhibit 1. Someplace up here, put Exhibit 1. File it at the same time that you file the exception. If for some reason, this isn't here when you go to do it, because God knows what they do to the internet after you start pointing shit out, right? You can always go down here to, right, LOC, which is librarycongress.gov. Excuse me, about this collection, go to Volume 1, which is the first Congress. All right, you'd have to download the whole thing, so go to Go. It's going to take a second to do this. It didn't take that long. But, it's not on the first page of this stuff. It's got like 140 pages of crap before it ever gets to any of the documents. All right, page 142 is, see there's 23 down there? This is 1stat23. So that's really what it means. That 23 means what page of the statutes of laws does it come in on. So now you would have to say print, and you'd be printing page 142 and 143. Right, the 2 pages that go with it. So there, there's your exhibit. Right, right, Statute 1, jeepers. Right, so someplace up here you're going to put, Exhibit 1, and that's what I'm talking about, to file with the exception. All right, hang on. All right, so here's our exception, and now, because we did the exception, and because of what is said in Rule 5.1, we're supposed to file a notice if we're going to bring up the constitutionality of a statute, which is what I plan on doing. I'm bringing up the constitutionality of 1stat23. Is it constitutional or not? So then you would have to have a notice, right? So, right, then you're going to file this in your court case. Right, because you're just going to serve a copy of it on the Attorney General. That's what it said to do. So, whatever name you put on your exception, there you go. Plaintiff's the same, defendant's the same, case the same. Right, but now we don't have a notice. Now we have a notice of constitutional question. Now comes, put your full legal name, right? A party of interest in this proceeding, having filed an exception entitled challenging the constitutional. Well, I got to change that because let me do that right now because I did change that a little bit. Right, challenging this proceeding and the constitutional qualifications of the court. Copy. Go over here. Replace this line. Challenging this proceeding and constitutional qualifications of officers of court and exhibit, right, whatever the exhibit number is for 1stat23. So, again, whatever you put in here is whatever you put, because you may already have exhibits in your court case. More than likely you don't. So you just put like Exhibit A, Exhibit 1, whatever you want to call it. Whatever you call it that's the same thing here. And the act is, right, it's an exhibit, and it's an act to regulate time, manner of administering certain oaths. Who now gives notice to the Attorney General of the United States the following constitutional question. Is it constitutional to require officers of the court in this proceeding to execute the oath in an act to regulate time and manner of administering certain oaths and have a record or certificate as proof that they are qualified to execute the duties of their respective office? Right, and you fill it out here, and Now, what I had suggested doing, if you're going to send this by certified mail, you just stick the certified mail sticker receipt that you get. We'll look at one of those in just a second. Right over top of this, I just put this here so you have the email address. But again, you may be able to just send this by over the mailing address, but you may be able to send it by email address, right? Because that's an option. It's just what is the email address that they have for doing it. And, today or tomorrow, I hope to have an answer, and I'll put it in the comments of the video or show it in my next video or whatever it is or whatever. But if you do it before then, well, you may just have to call or, send it by certified mail. So let's look at a certified mail receipt. Hang on a second. Okay, so, hey, this is what the receipt looks like. And to do what I'm suggesting, which is, they're going to, this part to the left of this dashed line is going to go on the envelope. But this part over here is your receipt. Well, I would really like to see them take that and I'll put it on your notice, right? Right here. And then make you a copy so you can mail a copy and keep the original. Right? That way when you go to court, you can make them a copy and keep the original. At the end of the day, you can keep the original. Now, to do that, you have to get the post office to, play along because they say, well, we don't make copies. You say, okay, well, let me take this and go, to the copy machine across the, well, you can't do that, right? Because, technically, what it would look like when you're done, when you get them to agree, is something like this. Excuse me. Right? It's glued on there. You put your name, full legal name, in the official use box, and you ask for it to be mailed, first class mail, which you can have added to. It's an addition to certified mail, so you got to ask for first class mail. And look, when you do, hey, they use a black postmark. If you don't, they're going to use a red postmark. Right? So, but Andre was able to get it done. Now, this was the version I tried before I noticed a constitutional question. But again, this was without having a full understanding of, well, there's actually supposed to be two documents. There's supposed to be your challenge, exception, right, and a notice. Two documents. But the notice is going to have this certified mail receipt on there, and you're supposed to send this and your exception to the Attorney General. All right, so you get two different documents. So sorry, Andre, we're going to have to do it again. What can I say? Or anybody else that I've told this, I told you when at the time, I don't know what I'm doing. I'm just practicing. Right? If I ever figure it out, well, it'll prove itself in court, and then I'll say, hey, this is how you do it. Until then, we're just trying things. So, okay, where was I? Let's go back to this here. Right, so where it says official use, you're supposed to put your full legal name in there. Right, and down here's the address. So you're going to put Attorney General of the United States. And then, where was his address at? Right, Attorney General of the United States, 950 Pennsylvania Avenue, Northwest, Washington, D.C., da-da-da, da-da-da, da-da-da. Now, you are not going to use a green card. Right? Read my lips. Don't get a green card. You don't need a green card. And they would tell you, if you're going to get a green card, to take this strip here and put it on the green card. Well, we're not going to do that. You could take that strip there and put it back over here on your notice, right, to show that you had mailed it. Well, sure, no, you don't have to put it on the service. We got one more document to look at. Right, so not on this, but this, if you can get the post office to play along, and I don't see why you can't, if the counter troll doesn't want to do it, tell them you need to talk to the attorney or to the postmaster. Even if you need to come back and do it again, whatever, it'd be really good if you could get that on there, because that's your proof of mailing. They call it a receipt, but that's the proof that you mailed it. And once it's been mailed, it's considered delivered. But if you get that freaking green card and you don't get it back, well, then you can't say it was delivered. So, and again, if it would be a lot easier, they would just tell us, well, this is the email address to use. And if they do, well, that's what we'll use. And we won't have to do all this shit. But until then, this is the one way to do it. So, hoorah. Right, and then finally, certificate of service, right? So again, the name of the court, plaintiff, defendant, all that shit stays the same. Now it's the certificate of service. A copy of notice of constitutional question what has been served on the Attorney General by certified mail in accordance with Federal Rules of Civil Procedure. I'm going to have to add in there a line and, let me do it right now. Yeah, more like this. A copy of the notice of constitutional question and the exception challenging this proceeding and constitutional qualifications of officers of the court was served on the Attorney General of the United States by certified mail in accordance with Federal Rules of Civil Procedure on whatever date, right? And, put the sticker right here, right? The little strip that's going to come off, right? And then continuing on, so that takes care of that. And on, the name of the chief judge of the court that you're dealing with, the proper name of the court, name of the chief judge, again, right? Call the clerk. Hey, who's the chief judge? Oh, we don't have one. Okay, well, who's in charge of administration of the court? What judge is that called? Oh, that's the presiding judge. Well, who's that? Okay, whoever they are, right? Whatever they say their title is, whatever they say their name is, whatever, just put it down there, right? And send it care of the clerk of the court's office, whatever that is, and the mailing address. Right, because all them judges have boxes or whatever down the clerk's office, right, where their paper's going to. And then on the plaintiff or the prosecutor, depending on if it's a criminal or civil case. Right, you're going to just send those by first-class mail. Certified mail, first-class postage. In accordance with Federal Rules of Civil Procedure, right? Right. If you want it to be mail, it has to be first-class postage. And if you just send it certified mail without paying and specifically asking for it to be first-class postage, they're going to send it standard, which isn't first-class postage. Right? You have to actually ask for it. And, that's written on the back of these things. So I had one sitting here somewhere. Hang on a second. Right, so certified mail may only be combined with first-class mail or priority mail. First-class mail. If a postmark on a certified mail receipt is desired, please present the article at the post office for postmarking. If a postmark on the certified mail receipt is not needed, attach and affix the label with the postage in the mail. Well, we want to have a postmark. All right, that's the proof is the postmark. So, all right, so basically when you go to the post office, you're going to go there with an envelope, or envelopes, 3 envelopes, already addressed to the people that are supposed to get them, right? But none of them will have anything in them. And you're going to go and tell them you want to send the one. Not the notice. All right, I want to send certified mail, first-class postage to the Attorney General of the United States. They're going to figure all that up, right? And now they're going to, hand you a receipt or whatever. And you want to put the receipt on the document. Say, now, can you make me a copy of this? Right? So you're going to put it on this. Not on that. On your notice. Right? Then ask them to make you a copy. So you can put it in the envelope along with a copy of the the exception that you filed in that you're going to file in your court case. Right? Now he has both the notice and the exception. Okay, boom, he's done. You can mail that one. Right? Now you have in your hand still the original copy that has the certified mail stamp on it with the postmark. Right? Now go make 2 more copies of that or 3 more copies. You don't need to do it there at the post office. If they make you 4 copies, that'd be wonderful. But they only make you 1, you can still do it. Just get the one mailed, go to a copy machine, and make 3 more copies. One for the one for the judge and one for the plaintiff or the prosecutor, and you can mail those. Right? Now they're all been mailed. Again, mail them a copy of the notice and a copy of the exception to each of them. So 2 pieces of paper going in each of them. And now you can go to court and give them a copy to file along with a copy of the exception. Right? File them in the court case. And then this, this is your certificate of service, and go to the notary, get notary work done on it, and that's the way I say to do it. If you want to do it a different way, what do I care? Right? I only care that somebody who's got a court case try to put this in, right? This exception, and let's get an answer from the Attorney General if these people need to take the oath to satisfy the 6th article of the Constitution or not. So that's kind of where we're headed. Okay, I want to show a few things that from my last video on the court case in New York where it did get dismissed. And so give me a second to bring those up. Hang on. Real quick though, first, right, this is used in a criminal case, right? And it says waiver Rule 5 and 5.1 hearings. Now, if you remember reading, you're not supposed to have a Rule 5.1 proceeding of any kind if the United States is a party to the action. Right? But it isn't. It's the United States of America. So that's why they got to have criminal cases, have people waive the right to have a Rule 5.1 hearing. All right, that's the way they get around it. Right? You're going to waive your right to identity hearing, a preliminary hearing, a detention hearing. All these things. And they have you sign it. Away goes your rights. All right, so what we're going to look at now, you could find for yourself if you just Googled New York Courts Electronic Filing and see the C-Filing page and click on it. It'll take you here and go down to this filing page and click on it. And go down here and search as a guest. Yep, telling me not a robot. I want the case number, which they call index numbers in New York, by the way. And it's 2019-52422, right? Anybody can go look at this. Great thing about New York is they have all the documents to look at for free. And click on it, and boom, here's all the documents that are in there. And these are the latest couple things we tried. Excuse me. After the decision and order, which is what we're going to look at now for the judge. Right? But I wanted to refile it, notice the constitutional question, and tried that. And, then I've come to the understanding I have now, and hey, we'll go try it again. Just keep throwing shit in the court case. So, what about this judge's decision? Well, first off, you'll see that she, based her decision on documents 22 to 46 and 58 to 60. Right? She didn't use any of these other ones, any of the stuff that was up here, like the summons and complaint. She didn't use that. Notice of pendency, certificate of marriage, none of that stuff meant anything to her. She didn't get interested until we got to 22. So, and then when you go down here to 26, it says exhibits, and when you open that, it's just a copy now as an exhibit of the summons and complaint. So here it was entered as a summons and complaint, and at 26 it was entered as a exhibit. And I remember helping a guy in a court case where the clerk had told me that you file paper in the clerk's office, it doesn't go to the court. It stays in the clerk's office. But she wouldn't give any more answers. She didn't ask more questions, and that's where that's sat ever since, right? But, exhibits go to the court. Apparently, they go to the court. Anyways. So, and she said that Shelley Jones executed a note endorsed in blank, which isn't really true. And that's what I pointed out. I mean, if you're interested in these last two here, this notice of unlawful conversion by plaintiff and malicious prosecution by its attorneys and victims request, blah, 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 blah. I'm pointing out all the things I'm going to tell you right now. All right, so Shelley Jones didn't execute a note endorsed in blank. After she signed a note, somebody put an endorsement on it, right? And they call it an allonge or an endorsement, but it's a stamp and it says pay to the order of on there. Well, pay to the order of is words used in a check, right? But she's pointed out that the guy used different dates in New York. They had to put in this 90-day notice, right? And so as of 8/21/2018, he was at 80-some days. But then later on, they put another piece of paper saying December 1st, he was at 90 days. All right, so, and she's going through all the things that the plaintiff did wrong. Plaintiff must submit proof of existence for the mortgage note and evidence of default, proper service of RPAPL 1304 notice, that's the 90-day notice, is a condition precedent. Plaintiff has a burden to establish satisfaction of this condition. A plaintiff must tender sufficient evidence demonstrating the absence of material issues to its strict compliance to 1304. Failure to show strict compliance requires dismissal. That's how she got out of the case. She said that the plaintiff didn't properly file the notice required by 1304. Right? But up here, she pointed out that the defendant filed a notice of constitutional questions. This submission appears to be directed to the New York State Attorney General's office and is not responsive to the motion pending before this court. In other words, it's not an answer to the proceeding, and it appears it was going to the New York State Attorney General's office. But, she's saying it doesn't really have much to do with me. Although, because of that is really the reason that she's dismissing this case. Where's that really good stuff here? Hang on a second. All right, the required content of 1304 is very specific. Service thereof is mandatory condition precedent. Plaintiff's failure to demonstrate compliance requires dismissal of the action. Defendant's cross motion should have been granted as plaintiff failed to raise tribal issue of fact, although the defendant failed to cross move on this issue. Right, this isn't an issue that the defendant made up or brought up, but it's the issue that the court's going to use to dismiss the case. Right, the date of default stated in Schedule E of the complaint and the affidavit in support of plaintiff's motion, that'd be Brown's affidavit, December 1st, 2018, is at odds with the date of default set forth in the 90-day pre-action statutory notice, which said August 21st, 2018. Thus, the 90-day notice required by our PAPL 1304 is defective on its face, and it fails to notify defendants of the correct default date. Consequently, plaintiff has failed to establish defendant's default in compliance with the 90-day pre-action notice statutory requirement. In addition, the sender of the 90-day notice is identified in the letterhead as Penny Mac, and its website identified as Penny Mac USA, neither of which matches the plaintiff's identity. Plaintiff has failed to establish that the sender of the 90-day notice was the plaintiff or had the authority to act on the plaintiff's behalf. So this document that they sent is a statutory requirement. It was supposed to go to the finance, like the treasurer of the state of New York. Well, they committed fraud. And so, as I'm telling Warren, Warren, I told Warren, go to the court and get a certified copy of this note or of this judge's decision and a certified copy of, we'll see it here in just a second, right? This is the document they were supposed to put in, right? Where it says Penny Mac, that's not the name of the plaintiff. And there's Penny Mac USA, again, not the name of the plaintiff, right? Get a certified copy of this, which is in document 35, right? And, of course, you're going to keep the ones you get certified, but make copies of them and contact the revenue, for the state of New York and say, hey, the judge said this stuff was done wrong. I've been damaged. And see what they say, right? They're going to have to go investigate the attorney that lied to the frickin' state. Okay, what else do I want to show you real quick? Oh, this is the affidavit they were supposed to put in. Right now up here, it's got file number XPNMN 153, Supreme Court of the State of New York, County of Dutchess. Well, that's not the proper name of the court. The proper name of the court, as a matter of fact, just so I can say that I showed it one time. Right, so New York State Unified Court System, 9th Judicial District, Dutchess Supreme Court. Right, that's the state court. Well, that isn't what they put on this document, so, this is part of their game. They're simulating a legal process under color of law. Right there. What else do I want to show real quick? What's on this? Okay, this is that Penny Mac. Yep. This is the letter. Yep. Exhibit A. Let me see. I want to find the note that she's supposed to have signed. Okay, so here's the note. All right, this was in the complaint. And it says it's a 3-page note. Well, page 1, page 2. There's page 3 with Sally Jones' name on it, and that's all there is. Well, then they put in this other document that says it's a note-a-lodge for Jones, Shelley, not Shelley Jones. Right? Where it says pay the order of, and it's blank, without recourse, Plaza Home Mortgage. If you sign here where it says pay the order of, you just put your name on a check. You should be able to negotiate this document just like a check. Well, in the court case, they put in this, right? It's got this certifying statement here by an attorney saying that this is the, true and correct copy. Note, 1 of 3, but there's only 2 pages in here. All right, then you got a blank piece of paper. Then at the bottom, it's got pay the order of, and it's got Penny Mac Loan Services without recourse and Plaza. Right, this is the same information that was on, right, Plaza Home Mortgage. Plaza Home Mortgage, right, but it looks like Penny Mac signed it. And then they put in another one, right, that's blank, and now it's Penny Mac that's without recourse, but this line is blank again. So I'm just saying, well, this is where you're supposed to sign, and, you will have basically completed the blank line on a check, and you should be able to take it and have it negotiated just like a check. So deposit it in your account, and tell them to let you know when it clears. Whether they'll do that or not, I don't know. I mean, what can I tell you? That's all just sideshow stuff. Really, the whole reason for the video was just getting back to this, right? Was I think we need to put in an exception. You put in an exception because by definition, that's the thing that is an allegation of a party in writing that some pleading or proceeding is in a cause is insufficient, right? And then you put in a notice of a constitutional question to satisfy Rule 5.1. In which you put the question, is it constitutional to require officers of the court in this proceeding to execute the oath in an act to regulate time, manner, of administering certain oaths, and have a record or certificate of proof that they qualified to execute the duties of their respective office? Right, mail them to the proper people and be done with it. So, okay, I got a couple of people that I've, have already doing this the way I said to do it before that I need to get with now to say, well, let's try it this way instead. But you get the idea of what we're trying, and follow along. We'll see what happens next. But if you have a court case, well, put it in yourself and see what happens. Please. All right. Y'all have a good day.